So we've seen a more simplistic and basic GPLP structure for what a lot of real estate investors like to see. But that structure can become more complex, as you'll see in this graph. I'm George Duby, saving the world from tax, one bow tie at a time. And it's not to say that you need every element of this. We're trying to present some possibilities that you should be talking with your advisors about in terms of whether or not it's right for you today, or maybe it's something that you morph into over a period of time. So, starting that off, one of the things we often speak with people about is whether the founder should have a nominee corporation. So, a nominee corporation would actually hold title to the real estate. For some legal reason, the limited partnership itself is not allowed to hold title to the real estate. And so it's usually going to be either the general partner, that corporation we discussed, or alternatively, a nominee corporation. And while from a tax perspective, I'm not aware of any difference, from a legal perspective, I've been told, and again, something to confirm with your legal team, that the nominee corporation may be of assistance from a land transfer tax perspective in terms of some possible transactions in the future. Other things to be considering. Should there be, for the founders, a management company? A management company may take some of the activities away from the general partner. So if the general partner is in some way almost a magnet, if you will, for lawsuits, then we don't necessarily want to see a whole lot of revenue stream going through the general partner. Based on the advice from your legal team, we may then set up a separate management company where that income can flow through to. So, for example, there may be an operating fee, a guarantee fee, a closing transaction fee, a financing fee, a this fee, a that fee. There can be a multitude of different fees, provided that the investors are accepting of these through the limited partnership agreement. We may, in addition to that, have an investment company created. That investment company, it's the intention there for the founders, instead of just having a relatively small fraction of a percentage of ownership, they may actually as well be putting some cash into the project and want to isolate the investment away from the general partner. So setting up a separate company to hold their investment within the LP is often something that makes sense. We may, in many cases, create a family trust. That family trust often owns that management company, the investment company, may also own something called a beneficiary company. And without getting into all the details, it may be thought of as almost a storage facility for cash flow. There can be legal and tax reasons for that. We can go another step. And again, this may not be on day one, and often is not, quite frankly. But we may set up what I'm going to call a TOSI family trust. And largely the purpose of that is to be able to split income with the founder's family while meeting requirements from Revenue Canada in terms of how we can and can't do that splitting. So on day one, we may have a very simple structure, but it may be something, again, we grow into a more complex structure over time. You need to be discussing with your accounting and legal advisors and finance advisors, quite frankly, what that structure should look like for you and when you should go to the next level. If you want to learn more about this topic, check out our GPLP playlist, or head over to my website, georgeedubey.com. No question, this series of recordings on the GPLP structuring is very high level, not a lot of detail. Please feel free to reach out, set up a time to talk further, and we can get into the nuts and bolts for what's right in your specific situation. Have more questions? Please subscribe, follow, and even share. I want all of us to have the tax information we need to do wonderful things.